Well, hello everybody. Welcome to another episode of Morning Latte with the Buechlers. And today we are going to talk about the U.S. Supreme Court. I'm William Buechler with the National Educators Law Institute and Buechler and Associates, and with me is my lovely wife and partner, Cynthia Buechler. And as we said, we're going to talk about the U.S. Supreme Court. So in the spring of every year, the U.S. Supreme Court issues its major decisions. They get about 7,000 to 8,000 petitions for review every year, which is a tremendous amount. And at the end of the day, they only hear about less than 1% of those cases that go to full briefing, argument, and a full decision is rendered. So in our context here with students with disabilities, it's fairly rare that we see one of these cases. It's probably about every 4 or 5 years. Obviously, it's extremely important when the Supreme Court speaks because every school district in the United States is bound by their determinations. So they're the final arbiter with respect to statutory law, federal statutory law, constitutional law, and that type of thing. So this decision we're going to talk about today, it's AJT versus Osceola Area Schools, and that's a case out of Minnesota. And it went to the U.S. Supreme Court based on a conflict of the circuits. So we have 13 circuits around the United States. Osceola Schools is located in the 8th Circuit, and it dealt with the standards under not so much IDEA, but under ADA and Section 504. And we'll go through that. So what we're going to do this afternoon is we're going to go through the facts of the case. We'll tell you what the lower courts did, what the Supreme Court did, and what concurring opinions were filed in addition to the majority opinion on this. And then we'll look at some of the highlights of it and some of the lessons that we learned from this case. So I'm going to let Cynthia start off here. She's going to give you some of the background facts, and then we'll move through the due process hearing and the court decisions and tell you what happened there.
Right. And what we have in this situation, there was a student who had a rare form of epilepsy that significantly impaired her physically and cognitively and her functioning in those areas. You know, she was one who required help with walking. She was someone who required help with toileting. So we had a really impaired child. And due to these episodes of her epilepsy and her seizures that she would have, the parent said, you know, the mornings are really bad, but she does pretty well between 12 and 6. And I requested instruction during that time. And in the original state in which they lived, they gave it to her. They gave her instruction from 12 to 6. Then they moved to Minnesota. And they still wanted the 12 to 6. And they said, no, it needs to be during the school day. And so she got instruction for 4.25 hours as opposed to the non-disabled kids who are getting 6.5. So the length of her day was shorter because she couldn't attend in the morning, and the school indicated that they would not go beyond the regular school hours. And so when the child got to the level of middle school and she's getting ready to go to middle school, they were going to reduce the time down more. And that's when the parents said, no, at least let her keep what amount of time she has, and the school was going to still reduce it down. And so they went ahead and filed an IDEA claim. So they filed for a due process hearing under that statute, under special ed. And they prevailed on it. They said you weren't providing commensurate day here. You unilaterally decided it wasn't based upon her individual needs, but based upon administrative convenience, and ordered hundreds of hours compensatory services, as well as ordering the school to provide services during that time period from 4:30 to 6 at home daily. And so it was appealed, and it went all the way up to the Federal Court of Appeals, which of course, as we've indicated before, is the 8th Circuit Federal Court of Appeals, and it was upheld. Once that occurred, the parents then sued under Section 504 as well as ADA and IDA, seeking permanent injunction, meaning they wanted the school from this point forward to have to provide that service of instruction during that 4:30 to 6. They also wanted to get damages, saying that the school had discriminated against them, because remember, Section 504 is a discrimination statute. It's supposed to prevent you discriminating against somebody who has a disability. And the same thing with Americans with Disabilities Act. Whenever a kid qualifies for special ed, remember, they're covered by all three of these statutes because we've determined they have a disability that is impacting their ability to learn, and therefore they're going to qualify under 504 and they're going to qualify under ADA. We don't create a different plan under 504 because they already have a plan under special ed. But what 504 does and what ADA does, it protects them against discrimination. And so they filed in federal court making those allegations.
So when the federal court analyzes these things, and this is true in all the circuits, but what's unique about the Eighth Circuit is that they have to have some level of intent. So it's not like a negligence standard. It's not that it just occurred. It has to be an action that the school district did that takes it to a very intentional level. And what the Monahan case had said in the Eighth Circuit is that the parents have to show bad faith or gross misconduct. And that's a very high standard. You know, to give examples of that, that would be like destroying a kid's student records or deliberately knowing something like medical records and refusing to consider that as part of developing an IEP or something along those lines. So it's a very high standard to meet. So when the parents sued under ADA and 504 in the district court said these allegations, that's not sufficient. Failure to accommodate does not equal bad faith or gross misconduct. The case went up to the Eighth Circuit Court of Appeals, and that court agreed on that, is that the facts of this case, you're not going to get there. So it's a very difficult standard to meet. So it went to the U.S. Supreme Court, and the Supreme Court agreed to hear this case because other circuits around the country it's still a high standard, but it's a lesser standard, and that's called deliberate indifference. Deliberate indifference is more of one where you know of something, but you failure to act appropriately. For example, a special ed kid getting bullied and they don't respond appropriately to that, or deliberately take action not to do it. So it's a little lesser standard, but there's still a level of intent. So when it went to the U.S. Supreme Court, that was that Monahan standard or that Eighth Circuit standard.
And that was for students. That was a separate standard for education.
For education, yeah, that's a very good point. So it's a separate standard than like an employment case under ADA or under Section 504. On the education side, it was just a higher standard that kind of sat there by itself.
So the education standard, they were saying it had to be bad faith or gross misjudgment, correct?
Correct.
So they were carving out a separate standard versus everybody else who sues under ADA and 504 just for education, and saying that under special ed, they wouldn't have required you to have that a lower standard. It needed a higher standard, correct?
Right. So the Supreme Court ruled on this case 9-0, which is rare. You don't usually get unanimous decisions like this. And it was 9-0, and the U.S. Supreme Court decided that the bad faith or gross misjudgment standard was not the appropriate standard. So, and that was kind of agreed to going into it. Even the school district at the argument had pretty much agreed that standard probably wasn't appropriate.
And that you couldn't have a separate standard just for education.
For education.
The statute didn't have different levels of standards for different cases.
Right. So do you want to talk a little bit about the opinion? Chief Justice Roberts wrote the opinion for the court, and you can tell us what they basically said in the 9-0 decision.
I agree. It goes back to, again, it's 9-0. So there was nobody disputing this. And again, as Bill indicated, even the school conceded that, hey, we agree there shouldn't be a separate standard. So as a result, they said, you can't carve out just by the courts themselves, unless the statute provides it, you can't carve out and create a new standard when the statute itself doesn't provide for that. So really the decision in that one was, to me, is pretty easy. Just saying, we've got to apply the same standard across the board for anybody who sues under 504 or ADA. And that includes somebody who's suing under the statute who is getting services under IDA. That was a simple thing. But they did have two concurring opinions. So could you explain to me what those concurring opinions are and what are concurring
Sure.
opinions?
A concurring opinion is where you a judge agrees with the outcome, but they might have different reasoning, or they may want to add a little bit to the opinion. So as we said, it was a 9-0 opinion, so everybody was on board with it. But two of the conservative justices, Justice Thomas, joined by Justice Kavanaugh, and two on the liberal wing of the court, did concurring opinions. So what Justice Thomas said is that all the court decided really what what the standard was not. In other words, it was not the bad faith or gross misjudgment, and basically invited litigants to we still need to address what is this issue across the board with ADA and Section 504. So Cynthia said the bad faith standard by the Eighth Circuit was in the educational context, but what we didn't get was the standard that applies in any ADA case or 504 case, whether it's a facilities case, whether it's an employment case or an educational case. So Justice Thomas seemed to be a little bit concerned in his concurring opinion that we were talking about injunctions and monetary damages, and there was discussion about different standards. So he basically invited litigants to bring this forward because we still have to decide this standard. On the liberal wing, on their concurring opinion, they basically got into that there's nothing that really indicates that you have to have a level of intent on these things. And they were looking at, for example, a building code. It might be well-meaning, but it still might violate one of these statutes. So what she was saying is that, well, you don't really have to have the intent component of it. Again, they saved that for another day. So we don't really know how that's going to come out. What we do know from this case is that bad faith, gross misjudgment is not the standard under ADA or 504. It's a little less than standard. We're probably still looking at deliberate indifference in most of the circuits, but the Supreme Court saved that for another day. So that's where we are on that. Now, can you give us some, everything, like we said, the Supreme Court applies to every school district in the country. What are some lessons that we've learned from this case?
What I found is more intriguing is actually the IDA claims. I don't see a big issue with the standard there, because even in the Fifth Circuit, we've never had a bad faith or gross misjudgment whenever we're applying the standard for 504 or ADA. The bigger issue for me was the fact that they said it wasn't a commensurate day. And the issue is, first of all, remember, we can never say we're doing something for administrative convenience. It has to be based upon what the child needs. So if you're having a child with a shortened day, it has to be because the child can't tolerate a longer day. The child is easily frustrated and can't do the work at the same time. And so making decision based upon this is how we do it, this is what we have, and this is what you're getting is always going to slam you. So obviously the facts of the IDA case were not what was in the process of being decided by the Supreme Court, but that really is the crux of how they even had the ability to try to file under 504 and ADA. So the bigger issue for me is, remember, whenever we're looking at a student, the question is, and we do with many students ask, do they need an extended school day or something of that? We need to make an individual decision. It may be the child can't tolerate a longer day. It may not be appropriate. Or if it's one where the child has so many seizures, and that happens. Some students have so much going on physically that it negatively impacts what happens within school. The question is then, would we provide them homebound services? And so remember, homebound, we can get credit within the state of Texas for 4 hours for a week versus 40 hours. It's clearly not commensurate with a non-disabled student's day, but it's still considered appropriate if that's what the child needs. Now, it's not an automatic 4 hours, that's just to get the money. It could be longer depending on what the child can tolerate. And so any decision you make, including homebound services, needs to be individualized based on what the student can actually participate in and what they actually need. And so that, I think, is the biggest advice I have for you. Never make decisions on administrative convenience. We used to have cases in the past that dealt with special ed transportation, and sometimes they'd say, well, we're going to pick those students up earlier. You have to dismiss them earlier so we can do a bus route for them. well, your day's been shortened. Sometimes only 15 minutes, but that's 15 minutes a day. Those students didn't get a commensurate day. Guess what the school's going to owe? 15 minutes for every day they've missed. And so we don't want to ever get in that situation to say that's how we do it. That's what they're getting. We want to say this is based upon that child's needs. As I said before, if you're going to shorten a kid's day, it needs to be based upon the child cannot tolerate a longer day. And so that would be the bigger issue. On the permanent injection thing, obviously that did not get decided by the Supreme Court. That was sent back down because the standard was wrong. That's what they were asking for. You can't get a permanent injection for placement. Every year we have to go over placement, and the child may not be able to tolerate a longer day. The child may need a shorter day, or the child may be able at some point to attend a full day of school. We don't know because we cannot anticipate from year to year what the student's going to do. That's why we have to meet annually. So I'd always keep that in mind, that we must meet annually on it and make a decision that is in the best interest of that child.
Yeah, I was just going to piggyback a little bit on that administrative convenience issue, because that does border on deliberate indifference. Like Cynthia said, you have to look at the specific needs of the student. And if the student needs a shortened day, that's fine. The IEP team can all agree on that. But if we start doing things because of cost perspectives, or it's just easier on staff, that even on the deliberate indifference, you're getting much closer there, because now we're looking at something that is, we know what the child's needs are, and we're essentially ignoring those needs because of these other situations going on. So yeah, besides having to look at the program, you do have to be careful of issues like administrative convenience and how that's framed, and make sure you're looking at the individual needs of the kid.
I think that's a really good point that you made, because the difference is to say that I developed a program based on what I thought were the individual needs that the IEP committee did, but it wasn't appropriate. That's a lot different versus saying, this is what this kid needs, but we're not going to do it. That's where you fall into that trap of 504 ADA, that you are not providing what the student needs. And that's something you always have to consider. We had a situation one time where the parent was requesting CART for their student because their child was hard of hearing, and she had cochlear implants. Well, they were using an FM device, but she wanted a transcription. The school went to the IEP meeting and said, wait, this isn't appropriate. What we have is appropriate. And I know this is a choice that you are seeking as a parent, but it's actually counterproductive, because by doing that, all she does is read a screen all day, then she's missing out on so much of language, which is nonverbal language, body language, that is essential for you to understand what is being said, and is it being sarcastic, is it literal? And so the IEP committee determined that that was not only not appropriate, but in fact would be detrimental. So those decisions that we make need to occur in that IEP meeting, and we need to obviously consider what the parent is seeking, but we ultimately have to do what we think is best for the student. When you start making decisions outside of that IEP meeting, that's when you start going astray and could be subject to damages, and you don't want that.
Yeah, you don't even want to get in that situation where you're trying to mediate that or whatever, because that's a hard thing to deal with. So, all right, well, we're going to be seeing this issue again. Obviously, the Supreme Court basically asked for the parties, or not these parties, but somebody to bring this issue again. So it wasn't totally resolved. Some of it was resolved, but not all of it was resolved. So we'll see this again one day. So anything else?
He definitely invited another case to come forward for them to be able to specifically address what is the standard that should be applied across the board. And so that's an interesting one there. The other thing is we will have a summary of this case and a link to the case on our website.
Yeah, nellylaw.net. We will have that available for you. And we hope you are not the school district that is the next one up there to decide that case. You know, hopefully that doesn't come into play, because we always want to avoid litigation, but that's why we do these little things and give our little tips on what we can recognize from the cases. So again, thank you very much for joining us with Morning Latte with the Buechlers, and we'll see you in our next episode.
Until the next time.